Welcome.
Thank you.
Glad to have you here. So S33, I would love for us to hear about it. It seems like a very long and detailed bill that we have a very, very tiny bit of jurisdiction over. So happy to be quite high level and just understand that little part more deeply.
Yeah, that sounds great.
Great.
Good afternoon, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here to talk, as the chair indicated, about Senate Bill number 33, which is the annual miscellaneous judiciary bill. Every year, I'm sure you've seen similar bills from committees of other jurisdiction, but in this case, it's the bill that the judiciary committees do every year to handle a number of different substantive pieces. There really isn't one way to describe the entire bill other than to say there's, many, many different parts to it, many different moving pieces. I apologize, I didn't bring my my laptop. You did was sent an email link, but I didn't realize thought it was just in case I wanted to testify by Zoom as opposed to actually bringing my document. But my understanding is that there's one section that's the jurisdiction of the Ways and Means Committee, section 9, if I'm looking at it correctly. So there isn't that much language to look at. It's actually quite brief. I can give you a moment or two on the background, if that might be helpful.
Yeah, that'd be great.
Okay, great. So this involves raising the jurisdictional threshold for small claims court. So as you may know, the way that one brings a lawsuit in Vermont can depend on the form that you bring it in, the court that you bring it in, can depend on the amount of damages that a person has. So if they're claiming that, it's because of a breach of contract or because of an automobile accident or whatever the case may be, maybe some goods that weren't paid for, whatever the reason is that's the basis of the lawsuit, the amount of money that they claim can dictate and influence what court they would bring that action in. Right now, under current law, if you claim $5,000 worth of damages or less, you can bring that action in small claims court. The filing fee in small claims court, depending on the amount of damages you're claiming, is usually from $60 to $90. So every court action you bring has a filing fee, and that's what it happens to be for small claims. If it's above $5,000 under current law, you would bring your action within the civil division of the Superior Court. That is the standard place that non-criminal cases are brought. The civil division is what it's called, as opposed to the small claims division. In that case, the filing fee is $295. So obviously a big difference between the amount of money you have to pay just to bring the action. Small claims court, as you probably have heard, is the intent of that is to create a proceeding that's more open to people who you don't have to hire a lawyer. You don't have to pay that fee. The filing fees are smaller. The rules of evidence aren't as strictly applicable. It's a more informal, it's often referred to as an informal process for people with smaller amounts of damages. So, and the threshold between the small claims and the civil division cases, as I mentioned, right now under current law is $5,000. So that's the background. The proposal here, as you can probably see, if it's behind me, it probably is, line 6 of page 6, is to increase that threshold from $5,000 to $10,000. The last time that this threshold was increased was in 2007. Back then, it was $3,500, which it had been for nearly 20 years. So it was increased from $3,500 to $5,000 in 2007, which is, 15, 16 years ago now. And I think that the Judiciary Committee's rationale essentially was that whether it's because of inflation and the increased costs of not only of goods, but of paying for an attorney and anything else that generally would go into the amount of damages that someone has when you have an injury to your person or property, that the time warranted an increase of that $5,000 to $10,000. So that's what happened in the Senate. So this is the Senate bill, as you can see. The miscellaneous bill, as it happens, rotate each year where the bill starts rotates. This year it was the Senate's turn. Next year it'll start in the House Judiciary Committee. This year happened to be, it started down in the Senate, and they added that change, that increased threshold from $5,000 to $10,000. There are a couple of exceptions in subsection E, you may notice, which is a little bit further down page 6, lines 14 to 18. Those were added by the House Judiciary Committee. So those were not in the bill as it passed the Senate. They were added in this body, and they apply to basically lawsuits on credit card transactions and lawsuits on medical debt. They heard testimony downstairs from Vermont Legal Aid and Disability Law Project that those types of actions were better to remain in the civil division when the amount of damages was between $5,000 and $10,000. So they took that testimony into account, carved out that exception for credit card transaction debt and medical debt, but otherwise kept that increased $5,000 to $10,000 threshold. I think why the bill is here, if I'm understanding it right, is something that I'm sure Ted will have more information than I do, but just speaking generally, is because, as I mentioned, the filing fee for a civil case in the civil division is $295, whereas the filing fee for a small claims case is $60 to $90. So if you increase that $5,000 to $10,000 threshold, then there's probably going to be some number of cases that under current law, say if you had $8,000 worth of damages, for example. Now, you don't have to bring that in small claims, but you would be able to if this bill passed, right? Because then the threshold would go up to $10,000. You could bring that case in small claims if you didn't want to bring it in the Superior Court. So there's probably going to be some number of cases that right now would pay a $295 filing fee, but in the future would pay a $60 or $90 filing fee. So I think that's could conceivably result in some decreased revenue for the court. That issue did come up generally without doing any detailed analysis of the amount of cases it might impact. And I do recall Chief Superior Judge Zone saying that he thought that the court would be able to absorb whatever that difference would be, but there wasn't any specifics about what it might be. Yeah.
So the filing fees, they stay the same?
Yeah, they're not changed exactly, right?
Can you tell us, do you have a section by section?
For the rest of the bill, you mean?
Yeah.
Yeah.
Okay, can you just go through it like lickety split?
Possibility. It takes like an hour to go through that whole bill. Yeah.
Okay.
No, so I could go through, I could start, you could stop me when you're ready.
Just like what each section of the bill is even. We don't even need to know about it.
Okay. I'll talk quickly. If I'm going too quickly, I can talk very quickly. Feel free to jump in if I am. Yes.
Yes, I mean, people.
Section 1's a purely technical fix, just increasing or adding a subsection heading that's not there. Section 2 has to do with giving the court the ability to assign other members of the judiciary to hear cases when they're short-staffed. Let's see, Section 3, also a technical fix, adds a conjunction. Section 4, this allows lay people, as opposed to attorneys, who attest rather than swear to documents that are filed in court. Right now, attorneys can just do a notarization. Is that good enough? Like, keep going? Okay, right. Section 5, another purely technical missing subsection heading. Section 6, that's also a missing section heading. Section 7 is these court rules have been renamed, so that's putting in the correct name. Section 8 is related to the Day is a Day initiative. I don't know if everybody remembers that. That's something the legislature did over the course of a couple of years to provide that any reference to days in statute related to court proceedings counts weekends and holidays. Didn't used to, now it does. Statutes have to be conformed to that. That's what's going on in Section 8. Section 9, we were just talking about the increase of the small claims threshold. Section 10 has to do with also updating some archaic language involving prisoner at the bar. It's sort of a funny one, actually, because if you think about it, criminal defendants in the old common law were referred to as the prisoner at the bar. Think visually what a courtroom looks like. There's a bar by the witness stand, and the defendant used to have to stand behind that bar. If you see some photographs of courts in other countries, sometimes they still do. So the reference was referred to as the prisoner at the bar. So we don't use that phrase anymore. We say defendant. So that was updated. You also see a change made in House Judiciary to provide people the option to affirm rather than swear. That's also in Section 10. Section 11, correcting a cross-reference. Section 12, that basically allows the state to appeal in a juvenile matter in the same way that can appeal in a criminal matter. Section 13, missing subsection purely technical. Section 14, this is actually in section 15 are both connected. That's clarifying that an offense involving an ignition interlock device is in the in the Judicial Bureau rather than the criminal court. Section 16 corrects a redundancy in language related to sheriff's fees. Section 17, this was actually, and 18 is the same thing, both recommended by the Juvenile Justice Stakeholders Group to allow for information to be transferred to counseling and restorative justice entities, despite notwithstanding the juvenile confidentiality law. So it's an exception to the juvenile confidentiality law for restorative justice. Let's see, the section 19, section 19 was part of that same thing. Section 20 does not, despite, if you were looking at it, does not create a new domestic terrorism statute, despite the underlying language under the domestic terrorism heading. It is moving the existing domestic terrorism statute, which you see in section 21, over to a new chapter. That's section 20. Wouldn't do that in a miscellaneous bill, probably could establish a domestic terrorism statute from out of whole cloth. That's true. That's true. I should say that. Section 22, that provides that for the state DNA database, when someone gets removed from the database, they can be notified by regular mail rather than certified mail. That ignition interlock device that I mentioned earlier, that's when someone gets a DUI. Sometimes you can have a IID, ignition interlock device, and still drive, as opposed to being suspended immediately. Section 23 addresses that situation and allows someone to get that device immediately, even when they've pled down to a negligent operation charge as opposed to a DUI charge. Section 24 extends the sunset on the Vermont Sentencing Commission by 2 years to 2025, and section 25 asks them, the Sentencing Commission, to do a report on stalking. Sections 26 and 27 are both related, and they were at a request by the Attorney General's office to that has to do with when the statute of limitations starts clicking in environmental contamination claims. Section 29 there's an existing law that prohibits sexual exploitation of a person who's in law enforcement custody. That makes a modification of that to clarify that it applies to people who are being investigated, detained, or arrested as well. Yep, so that clarifies that that's also prohibited. Section 30, this was, and actually section 29 as well. These were added by the House Judiciary Committee. They were not in the Senate bill. Same for section 30, which is to create an exception for the prohibition on possession of tobacco products by persons under 21. The exceptions for tobacco products that are used in connection with indigenous cultural tobacco practices. Section 31, that is also added by House Judiciary, and that is a technical fix that aligns the DUI statute with the blood testing statute for purposes of DUI investigations by law enforcement. Section 32 relates to an act that you passed last year, the legislature passed, that prohibited firearms in hospital buildings. There was an exception in the law last year for law enforcement. This adds some exceptions for law enforcement officers from other states, corrections officers, security guards, private investigators, so that those folks would not be prohibited from carrying their firearms in the hospital buildings.
Is that in the original bill or was that added?
That was added. The original bill had an exception for law enforcement.
Only,
Exactly.
That's what I thought. Okay.
Yep, that's exactly right. And let's see, section 33 and 34 and 35 are all connected, and they defer by 1 year from 2023 to 2024. The implementation of this Raise the Age initiative, which you may recall, which is raising the age of youth who can be treated as juveniles in the juvenile justice system. So that's supposed to go into effect July 1st this summer. The DCF has said they're not quite ready for it, so they're bumping it out by a year. Section 36 is, again, related to a similar sort of mailing issue that I mentioned earlier, but in a different context. This allows relief from abuse orders. Right now, the way the law is written, they have to be served on the defendant, even when the defendant's there in the courtroom and observing the proceeding, have gotten actual notice of it. They get notice of it, they're handed notice of it, and then the sheriff still has to personally serve them. It seems like a waste of time and resources. So they allow them to send it by regular mail rather than personal service if they've been there. If they haven't been there, then they still have to be served. And lastly, I think it's lastly, yes, a report on whether cash bail should be eliminated from the Vermont Sentencing Commission.
Thank you for doing that.
Yeah, sure.
You have to go down the whole bill, not just our many sections. So-
Yeah, I see, makes sense. I hope I wasn't too quick. That probably sets my record for speed on that one. Yes, sir.
It was perfect for me.
Oh, good.
Any questions?
Just refresh my memory. It's true that for our purposes, the change in the threshold or limit for small claims was not in the original proposal from judiciary, but the Senate added it?
No, the increase in the threshold was in the original proposal.
It was, okay.
Yeah, the thing that was added in the House Judiciary was the exception for
Okay.
credit card claims and on medical debt.
Okay, so the Senate actually didn't change. when
That
you said-
number.
Okay.
No,
It was in the judiciary proposal.
yes.
Okay,
Exactly.
got it. Thank you.
Yeah, sure.
Thank you very much for being
You
here.
bet. All right. Happy to do it.
Ted, I think you have a.
Thank you.
Thank you.
For the record, Ted Barnett, Joint Fiscal Office. I do have a fiscal note and it has a summary table that outlines the changes in the jurisdictional limit. Eric did a great job of explaining the mechanics of that for the purposes of this committee. For every case that is newly eligible to participate in a small claims court, that is a revenue loss of $205. They were paying the $295 filing fee for Superior Court. If they're able to file in small claims court, that's $90. We asked the Vermont Judiciary for information about how many cases would fall into that new limit. They don't collect that information, so I'm not able to give you an official forecast, except to say that there is a revenue loss and that these fees do flow into the general fund. And so roughly for, if you're anticipating 50 cases, that's about a $10,000 loss, but we really at JFI are not able to put an official estimate on this one.
Thanks for writing that all down.
Yes. I had it it was already there and I had already typed it out. So,
Oh.
yeah.
Makes more sense.
Yes.
Sort of shocked out that they don't have a number count for the docket.
Yes, they can tell whether it's filed and it's a small claims issue or a Superior Court, but yes, they do not have the official amount.
For how many would switch over, because that's what the threshold was for
yes.
that court. Yeah.
Yes. But I do have on the table, part of the table, it does provide information on the number of filings that fall into different limits to kind of give a potential bucket, but really in the world of Superior Court, the number of cases that fall on that threshold is probably pretty small.
Thanks, appreciate it.
Sure.
On a motion? Check. Madam Chair, I move we put this, I forget the number of the way we received it. Right?
That's 33.
That's 33. Thank you, ma'am.
And I'll second it.
Representative Maslin moves we find S 33. And Representative Anthony seconded. Any discussion? Seeing none, if the clerk could please call the roll.
Andrews, yes. Anthony,
Yep.
Beck, Brannigan,
Yes.
Shamrock,
Yes.
Maslin,
Yep.
Maddox,
Yep.
Cody,
Yes.
Sims,
Yes.
Taylor,
Yes.
Canfield,
Yes.
Kornheiser.
Yes.
1101.
Representative Maslin, will you report?
Oh, sure. Thank you. I'm looking for.
Somewhere between de minimis and
I just want to.
non-existent.
Well, it's not really de minimis, it's just not possible to be estimated,
Not possible.
which is different.
There you go, there you go.
Yes.
Okay, we have 5 minutes before Katie joins